Now convening the Council on Aging meeting for March 5th. Here it is already. Please, if you're able to stand, please stand and join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Francine, please call the roll.
Commissioner Allen. Here. Commissioner Fotheringham.
Here.
Commissioner Gorbach is absent. Commissioner Grimm.
Present.
Commissioner Healy.
Here.
Commissioner Kopaz.
Here.
Commissioner Loomis is absent, and Commissioner Norkin is absent. Commissioner Shantez. Thank you.
Well, good afternoon, everybody. And you folks in the back row, just because you're there doesn't mean you won't be called upon to answer some question. You can't hide from us. You just can't. But thank you for joining us here in the auditorium as well as at home. This is the time now. We'll go to public comments. First, we'll have Joseph Nassau. Joe, we'll make sure this is on. Yeah, either podium, Joe.
Quickly. I come from Boston. I do pronounce my R's, but nobody hears them. Okay. Attention all retired and 55 years and older senior citizens, but not limited to. If you have had a good life and feel it might be a good time to give a little back, then this might be of interest to you. You may want to mark the date, place, and time on your calendar. On March 20th, a Thursday, at 6:30 p.m. at the Senior Center, 3900 Avenue to Simi in Simi Valley, we will be holding a formation meeting of the For Seniors by Seniors organization. This is a brand new organization. The purpose will be twofold. One, to help all seniors, and two, to give extra help to seniors that are living below the poverty level. We will be looking for volunteers from all walks of life: mechanics, painters, plumbers, doctors, lawyers, tax people, and all those not listed, an opportunity to give back. We will be looking for you to give helpful discounts to all seniors and a little extra to seniors living below the poverty level. This help can make a profound meaning to these people's lives. This endeavor will need all the help it can get in all ways: time, effort, money, and ideas. I hope you can come to this meeting and give us your feedback. This will be a joint venture between Simi Valley and Thousand Oaks. We will be a nonprofit organization. Hope to see you at this meeting. There's a lot more that I couldn't put into this because I submitted this to the Daily News, the Star, and the Acorn, and I think all three of them are going to publish it. And what I'd like to add to it is we're looking for professional people and business people, not for them to pick up new customers looking for extra money. We're looking for somebody who's been successful in life and money is not a primary goal anymore, and they might want to give back a little more. I was just mentioning to somebody, AARP puts out a monthly newspaper, and about 6 or 8 months ago they put in a thing there that the main reason why the elderly have to file bankruptcy is because of the 20% thing in Medicare. And, you know, like I was just telling somebody, it's a fact that we borrow billions of dollars from China, and it's a fact that we give billions of dollars to countries around the world. I believe in foreign aid, but we got to take care of our own first. I think that should be at the top of the list. And if anybody has any questions.
I have personally worked with Joe on doing this. He has put in countless hours. It would be great for him to be able to get a response. We've also worked with CME, with the Senior Center there. So it would be wonderful if he could get a response from some local contractors that would be willing to give a little back at this time. So thanks, Joe. Thanks for your time.
Thank you.
Yeah, it certainly is commendable what you're doing, Joe. And we can, people here in the Thousand Oaks area can contact Francine as far as making other connections with you. Okay. So it is March 20th, which is about 2 weeks away, something like that.
Yeah.
So to put it on your calendar. It's a very worthwhile effort. Thank you, Joe, for your efforts.
Thank you.
The next person we have is Alison Barnes, a member of our SAMP team, who's got an energetic program to talk to us about. Allison?
I can do up or down right here. Okay. Hi, yes, I'm a member of the Recreation branch of the Recreation/Health Committee. Last year we had a youth versus experience tennis tournament, which was very successful. We had, I think the youngest kid was 9 years old, and we had people playing. I'm thinking that they might have been in their 70s. I didn't ask how old they were, but it was it actually was very competitive, very fun, and very inspirational. So this year we're having another Intergenerational Sports Expo, and the date for that one is April 4th, Friday at 4 o'clock. This one is going to be an exhibition of soccer and swimming. In general, the ages will be perhaps below 14 and above 45, so I know that's kind of a wide range. It's going to be a team event, and the great thing is we have the wonderful support of the City of Thousand Oaks, who is promoting this event as part of the 50th anniversary celebration. And thank you, Francine, for all your support, monetarily as well as psychically. They're providing materials, awards. Also, the City Youth Program is helping with marketing and organizing raffle prizes during the event. So what we would love to have is we just love to have people come and cheer for your team and be inspired once again this year. Thank you. At California Lutheran University. Thank you. Small detail there.
Yeah, and it's starting, it's like 4 o'clock or so?
It's 4 o'clock, yes.
4 o'clock to 7 o'clock, something like that.
Something like 2.5
Yeah.
hours? Okay. Thank you.
Now,
Sorry.
I meant to ask, are you looking for additional teams, or do you have the teams pretty well set right now?
We do have the teams. The coaches at CLU apparently recruited the teams, so they have all that covered. That's the great thing about this. Oh, I forgot to mention that Annette Breosma, who's my other person who works at the Reserve, they're also a sponsor. There's a few sponsors. But anyway, I just wanted to mention that she was brilliant enough to come up with the idea and actually sort of have CLU kind of take the ball and run with it. So I think we're in pretty good shape.
Okay.
Thank you.
All right, so yeah, kids and grandkids alike, as well as the grandparents, are certainly welcome to cheer and be a part of it. Okay, great. Well, good luck to you on that. Hope to hear more about it, and people, please watch in the paper for any kinds of ads about it. That's all we have for public comments. You ready to do the city website then? All right, once again, we're going to bring out the city's website as part of our continuing effort to acquaint folks with the website and the benefits, the things you can learn from it, how you can access it, how it can affect your life. So please, Francine, thank you.
Thanks, Trigrim. Okay, so today David has asked me to go over mind mixer and some things about our 50th anniversary that Allison was just talking about. So if you go to the city's homepage, which is again www.toaks.org or toaks.org, on the very front page you have a selection in pictures of the top 8 things that are going on in our city. And one of the first ones is Mind Mixer. So if you click on sign up to participate, you're going to come to a page like this, and in the first paragraph is the link to actually sign up. So we're going to actually do that this time. So we're going to go to Engage Mind Mixer. And if you click sign up, you can sign up in a number of different ways. You can sign up with your email. You can sign up to connect with Facebook, book, or your email. We're going to do sign up with email this time just so you can see what it looks like. So as you can see, the only things you have to put in there is your name, your email, the password that you want to use. And we require a birth date because you have to be of a certain age to participate. You have to be over 18. And then your postal code and male and female, and create your account. So it's pretty easy. So we're going to log in using my account so I can show you what it looks like. So when you do log in, after you've created your account, first you have to know what your email is. And mine's fspriegel@library.org in case anyone ever needs me. And when you log in, you're going to come to the home page of Mind Mixer, of the Thousand Oaks Mind Mixer. So it's going to tell you what your topic is for this month. And right now we're still collecting information on what your favorite ideas are for the city's 50th anniversary. So if you have an idea, you can type in your idea here and say continue, and it'll post it for you. So let's post oops. Well, goodness sakes, now you can all see that I don't know how to type. And then scroll down and just hit post your comment. Description. Oh, we're going to go back. So then after you've posted, you can go to the topics and you can see your posts, or you can go to activity. And if you go to activity, you can see everyone's posts. So you can see who's posting today. So this is an idea about celebrating local establishments and community. And there's some ideas about honoring oak trees, or displaying our 50th anniversary, doing a live history. So there's a lot of really great ideas here that you can look at, and you can rate them. So you can rate them with the stars. It's okay, like it or love it. And we kind of take a look at how many ratings, because we want to know how many people are really interested in doing that specific event. And it really helps the committee coordinate what's going to happen this year, since this is our anniversary. So after you've done that, and you have done your comments, or you've liked or not liked, if you want to see what's actually going to happen and the things that we've actually initiated to take place for the 50th anniversary based on some of these activity posts, you can come to the city's website again. But when you type in toaks.org, when you do / type in 50th, and it'll take you right to the city's 50th webpage. And on this webpage, you can see all the things that we've started. You can click on calendar of events, and you can pull up our calendar. You can actually sign up with Mind Mixer on here. You can order a historical commemorative calendar from here. You can learn about our geocaching event, which has commemorative coins, which is a really, really awesome program we're doing. The Caneo Open Space Challenge to get people more active in the community. Arbor Earth Day is going to have the Wyland Foundation Clean Water Mobile Learning Experience van there this year as part of our 50th, which will be great. The Youth versus Experience Sports Exhibition, which Allison was talking about. The Activate Caneo Valley Kickoff Fitness Fair on March 22nd in front of City Hall. We're hosting Amgen Tour to California for part of our 50th anniversary. And on Memorial Day, we're going to have a summer's concert series starring Beatlemania, because it's also their 50th anniversary of the Beatles' arrival to the USA. So that was kind of a good fit for us. And then the Civics Arts Plaza is also celebrating their 20th anniversary in October. So we'd love to see more ideas so we can add more things to this page about things we want to celebrate as we turn 50. So that's all I have today. Thanks, Dave.
A question. In the future, who will, or how do you generate topics? Or who's going to generate the topics?
I think the city manager's office is going to generate topics, and they're doing that based on input from the community. And city council, obviously, is going to be able to develop topics. So right now they're doing vision planning for the future.
Right.
So it's possible that some of the topics will fall in those areas of the vision planning.
Because this goes on to the end of March or so.
I believe that's what they have it on till, which doesn't mean that it'll stay up that whole time. But right now, that's
Okay.
the topic.
All right. So I guess this is I'm glad this is highlighted. I wish I could ask everybody to go on at least once a week to see what your friends and neighbors are doing. You can see there's a lot of things going on with just the 50th, but there's a lot of other activities, either through the calendar or other site that are showing you how progressive and how active this community is. So thank you again, Francine. I will go on to item 6 now, the liaison reports. Marty, please.
I'll begin with what's going on at the Global Adult Community Center. First of all, the Master Gardener Series is going to give Tree Care 101 on Saturday, March 22nd from 9:30 to 11:30 at the Global Adult Community Center. Tree expert Dr. James Downer from the University of California will be the featured speaker and lecture on proper tree pruning techniques. Dr. Downer will walk the Global Center gardens to examine and view trees. Another item is learn about laughter yoga on Wednesday, March 26th from 3:15 to 4:15 at Global. Learn about and experience the benefits of laughing yoga. Laughter is the best medicine. Laughter yoga uses yoga breathing to enhance well-being. Not yoga poses, so there is no flexibility required. He reversed it. The Caneo Senior Volunteer Program, CSVP, is continuing its free income tax preparation program at the Newbury Park Library and the Global Center locations. Here are a few numbers that you might not know about, which are increasing every day. The 1040 returns, they've done 313 at Global and 80 at Newbury Park. 220 of them were single, 60 of them were married filing a joint return, 3 were married filing separate returns, and 30 were head of household. The hours on here. The hours are, let me see, I have that somewhere. Yep. On every Wednesday until the middle of April, we will be at Newbury Park Library from 9 o'clock in the morning till 2 p.m. On Thursdays and Fridays at the Global Center, from 9 to 4 on Thursday and from 9 to 3 on Fridays. No appointments are taken. It's a first come, first served. Participants should bring the following items: a photo identification and a social security card. Also, social security cards for everybody you plan to put on your return, your spouse, your dependents, and all those. Bring your social security statement. Bring your wage and earning statements, W-2s and 1099s. Bring your property tax bill. Bring interest and dividend statements that you receive. Very useful will be a copy of last year's tax returns. And if you're planning on having your refund deposited to your bank account, make sure you bring that information. And any other information you can think about as to your income and your expenses. We do not do rental returns that have rental income. And if you have business expenses or business income and expenses that go on a Schedule C, we only do them if there is a profit and if your expenses are less than $5,000. That should cover it.
Thank you, Marty. Thank you. I know it's certainly, with the Master Gardener coming on board or being available, it's certainly pertinent these days with the way our drought situation is progressing. So if you folks, I know we got a lot of established homes that have big lots of grass and beautiful trees, but we may have to be moving away from that paradigm to something else, something a little more of a that accepts what we have for water in this area. So thank you, Marty. Okay, moving on to the next item, number 7, commission reports. Karen's not here, so Nance, could you bring us up to date on what you're looking for on Senior of the Year?
Absolutely. I don't know if everybody is familiar with our Senior of the Year program, but it's done the first Thursday of June every year, and it gives the community a chance to honor some of the volunteers who contribute so much. I mean, if you go and you think you volunteer a lot, you'll just be stunned by what some of these people put in all the time. So the nomination process is now open. The nominations have to be somebody who lives in the city of Thousand Oaks, and is volunteering for an organization. They need to have their nomination in by April 16th. And it's a really great thing to recognize somebody. I cannot emphasize how good these people feel to know that they were recognized for their volunteer work. It's June 5th, as I said. It'll be over at the Goebel Center. It's a dinner. It's always really lovely. It's Stonefire, I guess, catered by Stonefire again, which is really nice. So I'm going to show you, or I'm not. Francine is going to show you how to go online and get the application. And it's easy because I did it and sent it to someone the other day, so I know it's not hard. Okay, go ahead, Francine.
Okay, so if you go to toaks.org again, only this time when you do / you're going to type in seniors, and it's going to take you right to our senior services page, which you can find links to all of our meetings as well on here. But if you scroll down, you'll see Senior of the Year Award Ceremony and Social. It tells a little bit about the award ceremony, and if you click on nomination, packets are always available. You'll come to the nomination form. And it'll tell you everything you need to know. You can print from here, or you can fill out on here, and you can type it right in here and then print it. And then that can be delivered back to me at the Thousand Oaks Library, or you can mail it in, and the address is on the bottom. Thanks.
Francine, there is one qualifier. You do need to be 60 or over to do this. So please, I can't even tell people how nice it is for these folks to get recognized. They do an awful lot for this community. Thank you.
It really is quite impressive when we have the ceremony and you just sit there with your jaw open when you hear about the activity level of some of these seniors. It's just magnificent. Hopefully get some of those seniors into Joe's organization too, to pass along that energy to his efforts. So yeah, thank you, Nance, and appreciate all you folks who would be willing to, think of someone who you work with, who you've been around, who you know who's been doing a lot of volunteer work, and have them submit their name, or have your organization submit their name to help become a member, a candidate, I should say. All right, thank you. Moving on to item 8 now, commissioner comments and special event announcements. Anybody have something now?
Okay. I don't know how many people would be familiar with an organization, another nonprofit called Dining for Women. This organization has been going on for about 10 or 11 years. It was founded by a woman in South Carolina. Her name is Marsha Wallace. And the whole idea, it's called a giving circle. People get together at local homes, and everybody brings a lunch or a dinner, whatever meal it is, and you share, everybody brings it in, and then you share all the food, and at the end of the meal, you give whatever you would have spent if you went out to lunch or dinner locally. So $20, $25, depending on where you live. If you live someplace, it's probably a lot less. But and then all this money each month is donated to a special cause. Last month, we handled a charity, a women's-only charity in Kenya. And if we give them $15,000 because it is small, we go right to a small organization. It's amazing how far that can go in one of these countries. So if anybody's interested, the founder of this organization, and I'm going to have flyers out here, and you can look it up under Dining for Women. The founder is Marsha Wallace. She is going to be in town, and she's going to be speaking at the Center for Spiritual Living conference room at 880 Hampshire Road, Suite 5 in Westlake Village. It's totally free. If anybody's interested, they can call 818-746-7968 and just mention that you are interested in information about the founder of Dining for Women and attending. It's totally free. Or just look online for it and see what an interesting organization it is. And it has made a huge difference in the lives of very, very underprivileged women in very third world countries. So amazing how much they don't have. So thank you.
Okay, thanks, Nance. Francine, I don't know if this is appropriate, but with regard to the Vision 50 that the City Council is proposing, has anything been established as far as the dates when they're going to, I mean, I know they're supposed to do it every Tuesday that they don't have council meeting, but is that confirmed, and have they given a schedule?
Dates are actually posted on the city's website.
Where, city's website? Okay.
On the City Council page. If you go to
City Council page.
yeah, there's a report. And I can show that next time.
Yeah, but let's put that down there. But Deanna, all right. So, folks, there after the meeting of about 3 weeks ago, the city council members have assumed different areas of concern where Thousand Oaks will be in the next 50 years, and so they are determining, or they're getting into what they're going to have as far as meeting times and setting up, I guess, their agendas. So be watching for that. Hopefully, it will get up the website, but also any kind of news media. Anything else? Yes, Loretta?
Yeah, I just wanted to remind everybody about the presentation next Monday evening for the the health team. They're going to be presenting their last presentation in this current series, and it's going to be on East-West medicine. It'll be at 5:30, I think, in the library. So it's supposed to be very, very good.
Yeah, I've heard quite a bit of buzz about that. So I don't know how much room we got, Francine. Do you know? Are we?
71 reservations.
Oh, really? Okay, so the door is wide open, folks. But it's pretty fascinating. It's this area of East-West practices as far as medicine. So it's something that I'm glad to hear we're getting such a good response. Something along that line.
What's the time again? The time?
5:30.
5:30.
Yeah. Also on the medical list, I do want to wish Len Loomis the best in his travails with radiation. He's going through a series of radiation right now to help in a esophagus cancer problem. So get back here, Len. Anything else? It's not that I'm trying to stay away from Mary's speech by any stretch, folks, but just so it makes things clear. Roberta, you ready?
Yes, sir. Okay, thank you. We are honored today to have with us Mary Shea, a senior deputy public defender with the County of Ventura. Ms. Shea is a graduate of the Ventura College of Law and is an active member and past chair of the Ventura County Bar Association, Probate and Estate Planning Section, and a FAST team consultant, and she is going to explain what the FAST stands for. For the past 11 years, her practice has focused on probate conservatorships and guardianships, and she is here today to share her knowledge in these areas with us. Welcome, Mary.
Thank you, and welcome to all of you. Thank you for having me this afternoon. It's a pleasure to be here.
Mary, can I get you to be a little closer to the microphone?
Absolutely. Absolutely.
Thank you.
Thank you. Thank you for having me this afternoon. As you explained, I am a member of the FAST team, and I think, Roberta, you wanted to know a little bit more about the FAST team. The FAST team stands for Financial Abuse Specialist Team, and it's an organization of collaboration of a variety of different disciplines and professions that meet to essentially assist our Adult Protective Services organization with those complicated cases that we encounter out in the community. We focus primarily on the financial abuse. And what happens is these members meet once a month, and a hypothetical case presentation is made, and it's oftentimes based upon a real situation out in the community. And all of these members of the team essentially engage in brainstorming to try to assist Adult Protective Services in resolving whatever problem has been presented. This organization also provides presentations to the members of the FAST team, so it's an educational organization, and it also provides public education in regards to financial elder abuse and helps protect elders in the community and to be more knowledgeable of the scams that are currently out there, how to avoid them, and who they can contact if they have been a victim. So that's essentially what the FAST team stands for. I'm sure many of you are probably wondering why a public defender would be here speaking about the topic of conservatorships, because it is highly unusual that a public defender would be talking about this type of topic. Generally speaking, public defenders represent criminal defendants who have been charged with crimes and who happen to be indigent and can't afford their own legal representation. Well, that form of representation is a constitutional right. In what I do, it's a state statutory right to have counsel appointed to represent an individual who is what's called a proposed conservatee. And the reason for that statutory right is because that individual loses liberties, loses rights, loses the ability to make their own decisions in regards to everything that impacts their life. So that is the reason why public defenders do get appointed in these matters. Also, private counsel can be appointed. So perhaps depending upon the size of the estate and sometimes the complexity, the court 90 to 95% of the time will appoint the public defender's office in this capacity. So we handle currently slightly over 600 conservatorship matters for our office and for our community. So why is this topic important to us? Let me talk about some of the statistics I just pulled up yesterday on the Alzheimer's Association website. Quite astounding, frankly. Currently, over 5 million Americans are living with Alzheimer's, and as many as 16 million will have this disease in 2050. Pretty scary, okay? Right now, just today, an American develops Alzheimer's disease every 68 seconds, and by 2050, it will be every 33 seconds. Dementia now is the second largest contributor to death among our older Americans. This is why this topic is important, because this is a vehicle that allows us to become surrogate decision makers for those individuals that can no longer make decisions for themselves. And of course, conservatorships don't just apply to persons with Alzheimer's or dementia. It could be stroke victims that have lost their ability to communicate or provide for themselves, either personally or financially. It could be developmentally delayed individuals. It could be individuals who have suffered a traumatic brain injury. So essentially, it would be for any adult that has been determined to lose the ability to provide for their food, clothing, shelter, or to manage their finances, and or who may be subject to undue influence because of some deficiency. Okay? So, as I say, a conservatorship is one legal means to where an individual can become a surrogate decision maker. So what exactly is a conservatorship? Many of us have heard the term guardianship and are probably more familiar with what a guardianship is. They're very similar. The primary distinction between a conservatorship and a guardianship is that a conservatorship involves adults, whereas a guardianship is a similar legal proceeding where surrogate decision maker is appointed, but they're appointed to oversee the decisions and care of a minor. Okay, so those are the major distinctions. Now, in some states, they call conservatorships guardianships, or they split the baby, so to speak, and they call a conservatorship over the person a guardianship and a conservatorship over the estate a conservatorship. But here in California, a conservatorship can cover both person and estate, and it's going to be adults only. Okay, and a conservatorship is essentially a legal proceeding where an individual goes to court, files the appropriate paperwork, and is asking the court to be appointed or to have somebody else appointed to step into the shoes of somebody else, the conserved person, to make decisions on their behalf, including anything from medical to financial transactional matters, care, where they live, etc. And I'll go into more detail in those items. In California, we have a variety of different types of conservatorships. I practice primarily in the probate court, so we have probate conservatorships. We also have what are called LPS conservatorships, and I do handle those on occasion as well. An LPS conservatorship deals specifically with those who are in a mental health treatment facility, okay? And then we have limited conservatorships. So going back, in a probate conservatorship, I'll break down some definitions. You have a petitioner, the person that files the paperwork, that goes to court to ask the judge, I want to be appointed this person's conservator. The person that they're referring to is called the conservatee, the person who is conserved, the person that needs assistance or decisions made on their behalf, okay? So you have a petitioner who can become or be appointed the conservator, and then you have the conservatee, the person who has been conserved, okay? In a probate conservatorship, you can ask to be appointed the conservator over the person and or over the person's estate. You can also have two different conservators, one over the person and a different one over the estate, or you can have co-conservators who are both conservators over the person and the estate. So there's a variety of approaches. So if you have a large family or a number of interested persons, maybe someone is more skilled with finances, maybe someone's more skilled with medical, you might want to split the duties and you take on this responsibility and the other person takes on the other. There's a variety of reasons why you might want to approach it that way. Maybe there are family members, one close to the senior, one that lives further away. The one further away maybe can manage the finances better. The one closer to home can manage the physical care, the medical care, the placement issues, okay? So those are some of the reasons why you might have a multitude of conservators. That's more rare. Generally, the local courts see a primary conservator, but it's not uncommon to have co-conservators, perhaps siblings, involved in the conservatorship process. In order for the court to establish a conservatorship over the person, the court has to determine that the conserved person or the proposed conservatee is unable to provide for their food, clothing, and shelter. In order for the court to appoint a conservator over the estate, the court must determine that the person is unable to manage their finances and or is subject to undue influence or fraud. Okay, so we have a lot of seniors, unfortunately, out there who have become victims of all sorts of terrible scams. And because of their perhaps disease process or mental function deficits, they cannot appreciate the fact that they have become a victim. Okay, and they have become subject to undue influence by the bad doers. And so in those circumstances, a loved one, interested person, family member could petition the court to become their conservator, to step in, take over their finances so that they can preserve, protect, and maintain the status quo so they don't give away everything that they have. Okay, now who can file a petition for conservatorship? Any interested person can file a probate conservatorship. It could be a neighbor, it could be a best friend, it could be a spouse, it could be any family member. The statutes do provide for preferences. It'll start out spouse, parent, child, and kind of goes down. The last one being the public entity, public guardian's office. The proposed conservatee in prior estate planning documents can actually nominate who they would want to be appointed in the event they needed a conservator. So that carries a lot of weight. That's not definitive for the court, however, because the court has to always, first and foremost, look at what is in the best interest of its proposed conservatee. So let's say mom, years earlier nominates daughter, for instance. In the event I need to have a conservator, I want my daughter to be the one. Well, maybe daughter hasn't turned out to be the best daughter that she could be, and maybe when she petitions for conservatorship, she might not be the best person for that job. And so even though the proposed conservator can choose, and they think they're choosing wisely, the court must always look at what is in the best interest, because it's the court's role to supervise and protect. And so it has to take that into consideration. So bottom line, anybody can petition, but they are going to go through an investigation to determine if they are the most appropriate, best person to serve in that capacity. Okay. There, in all areas of law, when you have to establish something or establish evidence, there are burdens of proof. Okay. Many of you are probably most familiar with the burden of proof beyond a reasonable doubt. Sound familiar? That is not the burden in a probate conservatorship. It's clear and convincing. It's a notch down from that, okay? The proposed conservatee is entitled to have a jury trial, believe it or not, if they object to the establishment of a conservatorship. That's right. They can have a jury trial. They can have, members of the community, their peers, listen to the evidence and make a determination as to whether or not they believe they need a conservatorship. Now, what's interesting with the jury trial is that the jurors only get to determine the need. Is there a need? It's within the sole province of the judge to determine the who is appropriate. So there is a dichotomy in the decision making there. So jury decides the need, and then the judge would decide the who. Okay. I'll go into a little bit more detail a little bit down the road in regards to how we get there. I'm just kind of trying to cover some of the overall basics here. The probate conservatorship, once it's established, is permanent. It does not get renewed annually. It's permanent until the proposed conservatee or the conservator goes back to court to request termination or upon death. And I'll talk about what happens at that stage. And so once it's granted, it's there to stay unless someone brings it back before the judge to request a termination. And there's a variety of ways or reasons why you would want to do that. A little bit later in the conversation, I'll discuss the powers that a conservator will have once appointed. But what I want to point out here, because we're going to talk about LPS conservatorships next, in a probate conservatorship, and this is important to know, okay, the conservator does not have legal authority to place the conservatee in a locked mental health treatment facility. Okay, now there is this caveat. Always in law, there is an exception, right? If this conservatorship grants the conservator what are called dementia powers or dementia authorities, and it's determined that the conservatee has dementia, and there is evidence to support the need that they need to be placed in a locked facility for the treatment of dementia, very specific for the treatment of dementia, perhaps because they're wanderers and it's a safety issue, then the conservator can have the authority to place that individual in what we would call a dementia ward or a memory unit, okay? That is the only exception in a probate conservatorship that would allow an individual to be secured, in essence, okay? That is the major distinction between a probate conservatorship and the LPS conservatorship. So let's talk about that for a moment. In an LPS conservatorship, the conservator can be the conservator over both the person and the estate. So that's a similarity between the two. However, in order for an LPS conservatorship to even be initiated, the proposed conservatee must be in a mental health locked treatment facility. So if they're not there, even though they might need to be there, you can't get one initiated, okay? The other major distinction is that in a probate conservatorship, there's a variety of causes, let's say, that can create the need. The Alzheimer's, the dementia, the stroke, the developmentally delayed, etc. In an LPS, you have to have a diagnosis of a mental illness that causes you to be gravely disabled to such a degree that you cannot provide for yourself. Okay, so that's it. Again, is a major distinction. So you have to be in a mental health treatment facility. You have to have a mental health diagnosis. Okay. The third major distinction is not anybody can file the petition. The only person or entity that can file a petition for an LPS conservatorship is the Public Guardian's Office of the county. Okay. Now, they have to initiate the petition. A family member can ultimately be appointed, but they have to initiate it. Okay, nobody else can start that ball rolling. It has to be the Public Guardian's Office. And another major distinction between the probate and the LPS is that the LPS is renewed annually, and there's a reason for that. In probate conservatorships, most often the types of processes or diseases that we're dealing with are incurable. Let's say for a developmentally disabled individual, they're not going to get better. Sadly, at least at this stage in Alzheimer's, we're not going to get better. In the case of an LPS situation where the person is diagnosed with a mental health disorder, there is a chance that they could improve. There is a chance with proper medications and proper treatment that they can at some point in time again take over their lives, make their decisions, manage their lives without the assistance of another. And so those types of conservatorships have to be reviewed on an annual basis to see, is there improvement and is there still a need? So it is not permanent, unlike a probate conservatorship is. Okay. The other major distinction is that the burden of proof is higher. It is the same burden of proof that we are familiar with in criminal proceedings. They must establish evidence beyond a reasonable doubt. And the reason for that is because of the stigma that attaches to mental health and those that suffer from those disorders, and those proceedings are more akin to a quasi-criminal proceeding. They haven't committed a crime, but it's looked at in that way, and so a higher standard of proof must be applied. Okay? The powers that a conservator in an LPS has are slightly different as well when it comes to the person. Okay, because the conservatorship, let's say it's the public guardian that's appointed to be the conservator, their medical powers over that person are specifically directed to the care and treatment of the mental disorder. So they don't start out having exclusive medical authority to make all medical decisions. Let's say someone with a mental health disorder has to have a surgery. That public guardian has to go back into court and ask for specific medical authority to authorize that procedure. Whereas in a probate conservatorship, most often the conservator is given exclusive medical authority to make all medical decisions in that person's best interest. So the LPS is very focused on the treatment of that mental health disorder. As it relates to the estate, It's exactly the same as a probate conservatorship over the estate. They have to secure assets, manage the assets, pay the bills, the debts, etc. Okay, so that is exactly the same. Over the person, it's much more narrowly defined in an LPS. Okay, so that we have probate conservatorship, we have an LPS conservatorship, and now we have a limited conservatorship. Limited conservatorship deals with those individuals that have been deemed developmentally delayed prior to the age of 18, and it's of an indefinite duration, okay? And these are often individuals who are receiving services from the Tri-Counties Regional Center, okay? You can have a conservatorship over the person and estate here also, but the purpose of a limited probate conservatorship is really to promote the independence of the individual. Oftentimes we have developmentally delayed adults that are very high functioning. So you don't want to take away all their rights or all of their ability to do things for themselves. You want to promote it and advance it. And thus they created this limited conservatorship process. In this instance, we're back to where we were in a probate conservatorship. Any interested person may file a petition for a limited conservatorship. Same standard of proof as the probate conservatorship, clear and convincing. And also same as probate, it is also permanent unless someone goes back to court to terminate it for valid reasons. Okay. In a limited conservatorship, the powers are very definite. There are 7 specific powers that a limited conservator can ask for. They can ask for the power to fix the individual's residence, to access their confidential records, to consent or withhold consent to marriage, to limit their right to contract, to give or withhold medical consent, to control social and sexual relationships, and make decisions regarding education. Okay? In order for the person who's petitioning for this power, they have to delineate what powers they're seeking. And before the court can grant any or all of those powers, the court must receive what's called a tri-county report. So a psychologist from tri-counties has to review the individual's medical records, their IEPs, talk to the parents, talk to the social workers, talk to the individual, the proposed conservatee, do an assessment, and then the reporter has to make a report and assess each and every power that the conservator is asking for and make a recommendation as to whether or not, in his or her professional opinion, it's appropriate to give the conservator this power. Because again, remember, the whole purpose of the limited is we want this individual to be as independent and advanced as possible. So we want to give them as much authority as they can handle and that is safe for them. And so they're very cautious in making that determination. Thus, we have that report from Tri-Counties, and we can't move forward on a limited conservatorship without that input from that psychologist from Tri-Counties Regional Center. Now, before the court can even consider granting any of these conservatorships, it must determine that there are no less restrictive alternatives. Because when you think about it, and you'll learn as we go on, conservatorships are very restrictive. They take away people's rights, and we want to consider all other available options before we have to do that, right? And so what are some of the less restrictive alternatives? And I'm going to focus primarily and mostly the rest of the conversation on probate conservatorships, okay? In a probate conservatorship, if the proposed conservatee did some prior estate planning, then we might be okay. If they have an advanced health care directive that basically lays out to their agent that they've designated, this is what I want to have happen in the event I can't make my own decisions. This is what you can do. This is what you can't do, and is very specific, okay? Then we might be able to avoid a conservatorship over the person because that individual has already selected someone and has already given them the power to take care of them when they become unable to take care of themselves. So that's one possible less restrictive alternative. And that relates to the person. So what's a less restrictive alternative over the estate? if the person has a power of attorney that's expansive enough, okay, and gives enough powers and authorities over all of their estate to deal with every aspect of their estate, then we might be able to avoid a conservatorship. Now, sometimes you do all this great planning, right? And yet you still see someone file a petition for conservatorship. And well, why would that be? Because you have a conflict. Conflict perhaps between family members. Maybe you have an old power of attorney and advance health care directive, and some child of the proposed conservatee has taken mom or dad to see a lawyer. And now, all of a sudden, we have a new document that has appointed somebody different. And so we have conflict. So generally, when you have these documents in pre-planning, we see these cases come into court when there is a conflict between documents or a power struggle over who's going to be in charge. Okay. Another possible alternative or less restrictive alternative would be if there was a trust. And of course, a trust, again, is only going to be dealing with the estate aspect of an individual's life. So you've got advanced health care directive, power of attorney, trust. And then lastly, if the individual is receptive and cooperative to third-party assistance, okay, even though they might have deficits and they can't make decisions themselves, if they're cooperative in allowing someone else to help them, that may be sufficient for a while to avoid the conservatorship. There are instances where you might have to deal with institutions, banking institutions, okay, where you want to do some banking for mom or dad, and the bank, well, you're not on the account, I can't deal with you. Then you know you've come to a point, well, I can't do this for mom or dad anymore. Now I need that legal authority that I don't have. And so as long as institutions and doctors and those that mom or dad deals with or your loved one deals with continue to work with you, and mom or dad allow you to work with them, it could work. But as soon as those third parties start saying, nope, where's your legal authority to act on behalf of mom or dad, then you are faced with the possibility of having to go to court and seek a conservatorship so that you can be granted that legal authority to help take care of your loved one. Okay, so those are some of the things that the court must determine before it says, okay, I'm going to give you a conservatorship. Okay, so we've talked about the various types of conservatorships. Okay, so we have an idea of what it is and the types that we have out there. How do you get one? Okay, first of all, you have to file a petition. And what does that mean? There are what are called judicial counsel forms. They're state-mandated forms, okay, where you check a bunch of boxes and you fill in some information. You can go to our local self-help legal access centers, and they can print these documents for you. They cannot give you legal advice. They can give you some guidance, and they can provide you with the forms, but you're pretty much on your own. You're representing yourself. You're in pro per, as they say. Okay? You can hire an attorney that specializes in conservatorships and probate matters. Those are basically your choices. Or you figure it out. You go online, you download the forms, you fill them out, and you get them filed, and you make your appearance in court. So those are the ways that you can get the process started, because that's the only way the court can consider a conservatorship is if these documents are, the appropriate documents are filed, and it's before the court. There's a hearing that's been set. Otherwise, nothing will happen. There are different types of conservatorships. You can have an ex parte hearing, or I should say different types of hearings, an ex parte hearing, temporary conservatorship, and the permanent. An ex parte temporary conservatorship is reserved for those situations where there's a true emergency. And depending upon what jurisdiction you're in and what judge you're in front of, that is kind of a moving target. What you might consider as an emergency, the judge might not consider an emergency. So your best bet, if you don't know, is talk to somebody who knows the judge or knows what an emergency might really be, because you don't want to spin your wheels or spend unnecessary funds to have that special set hearing to only be turned away and say, I'll see you in 30 days. Okay. Our local judge really reserves these ex parte hearings for for emergencies dealing with the person. Is there a medical emergency with no legal authority? Is this person, going to die if we don't do something now? Oftentimes, if there's a conflict between family members or an allegation that, Joey's stealing from mom or whatever, not oftentimes considered an emergency by our local court. But don't hold me to that. That could always change. Each case is looked at on a case-by-case basis. So just to kind of give you a heads up on that matter. When a petition for conservatorship is filed, and this surprises people, all the relatives within the second degree must receive notice. You're like, well, why do I have to tell the whole family? Well, the reason for that, is so that everybody that might be interested in the care of this individual would have an opportunity to, one, step up and say, no, I want that job. Or, no, that's not a good person for the job. Or just simply be there and support the individual that's asking to be appointed. So you want everybody in your family to know. It's interesting because I represent the seniors, or the adult that is going to be conserved or may be conserved. Oftentimes, my clients don't want the family to know because it's an embarrassing situation. It's a lot of confidential information that's being provided, and maybe they haven't had contact with family members for quite some time, or there's estranged family members. Unless there is good cause presented to the court wherein it would cause some detriment to the proposed conservatee, they must be notified. Unless there's some harm that's going to come to that individual, they must receive notice. So if you're one of those family members, you're getting a packet in the mail, like, why did I get this? I don't have anything to do with it. That is why, because the state requires that notice to give you an opportunity to be heard. Once the petition is filed and everybody is served, the proposed conservatee must be personally served with a citation. So somebody must go right to the proposed conserved person and say, here you go. Here's your paperwork. This is what's happening. They don't tell them, but essentially the paperwork will tell them somebody is seeking a conservatorship over you, because the court wants to make absolutely sure that this person's rights aren't being taken away without them knowing, So it's very important that they are personally served with these petitions for conservatorship. So you have the petition, you get it filed, you make a decision, is this an emergency or not? Do we need a temporary conservatorship, or do we wait for the permanent hearing? Have we served all the relatives within the second degree? Have we served the proposed conservatee personally? You have all of that. You've filed all the paperwork with the clerk's office. The clerk is going to issue a hearing date. Oftentimes, once you file the paperwork, your hearing date isn't maybe 45 to 60 days down. It's down the road. And so that's one thing you have to consider when you're filing the paperwork. Do I really have an emergency? Do I need something sooner rather than later? And that's part of your thought process when you file. So let's say you've gotten to that point. What evidence does the court need to receive in order to grant your request? Primarily, number one, less restrictive alternatives has to look at that. That's off the table. There are no less restrictive alternatives. There was no prior estate planning, or there's a conflict between documents, so we can't resolve that. So now we have to move forward to a more restrictive proceeding. The court has to make a judicial determination that the proposed conservatee lacks capacity to basically self-determine at this point over their person and over their finances, or one or the other. That is the primary hurdle and the primary evidence that the court must receive before it can make that order and grant the conservatorship. So how does it receive that evidence? As I mentioned before, the Judicial Counsel forms, there are many, many forms, and one, among those forms is what's called a capacity declaration, a medical capacity declaration. This declaration is completed by a psychologist, psychiatrist, or the treating physician. And this document is, I think, a 4-page document that breaks down cognitive functions. So it's a capacity, a cognition determination, And the various categories that are being assessed are alertness, Information processing, can the person process information, and if so, how well or not? Do they have any memory impairments, and if so, how severe are they? Do they have any reasoning abilities? Do they have take to carry out actions in their own self-interest? Functional capacities? Can they go to the grocery store? Can they, take care of personal hygiene? Can they prepare meals for themselves? Basic day-to-day activities that we kind of take for granted. Do they have any delusional thought processes, disorganized thinking, and the ability to modulate their moods? Are they up and down and all over the place? So these are the types of categories and mental function deficits that this professional has to assess. And then there are boxes to check, and there are degrees, A, B, C, or D, not impaired, mildly impaired, moderately, severely, and so impaired I can't evaluate. Okay, that's the D or the E. And so with this document, this is filed with the clerk. And so this is a significant part of the evidence that the court must have before it can grant the conservatorship. Because again, the conservatorship can only be established as the person lacks capacity. And how do we know they lack capacity? Because a professional is telling us they do. Now, like in every legal situation, you can have competing experts or competing opinions. It doesn't happen that often in conservatorships, but it can. Okay, it can. So you can have one doctor say, oh, no, this person's fine, and another doctor says, oh, no, they're not. Again, very rare situation, especially, when we're dealing, with the traumatic brain injury or, the moderate to severe onset of dementia or Alzheimer's. It's just, there doesn't become that question involved at that point. What's really important to know, however, is the mere diagnosis, of a mental disorder or disease is not sufficient. So if a doctor says, Mom, you've got dementia, and they go, oh gosh, I have to go get a conservatorship now, daughter. Just the mere diagnosis is not sufficient, In order for the court to grant the conservatorship, it has to consider, number one, is there a mental function deficit? And is that deficit so severe in frequency and duration to impair that person's ability to provide for themselves or manage their finances? So there has to be a correlation between that deficit, that mental function deficit, and their ability to carry out taking care of themselves in essence. So just the diagnosis alone isn't going to get you the conservatorship. You have to have enough facts and enough evidence to support, a history of an inability to provide for themselves. Perhaps it's an ongoing undue influence situation with scams, or an inability to reason and rationalize and make any medical decisions on their behalf because they can't understand their diagnosis or their disease. They can't process the information anymore that the doctor is giving them. They can't decide what is best to do or not to do if it comes to medical procedure. So there has to be this backup information, factual information. Now, of course, all facts can be disputed, right? So if you have a proposed conservatee that says, I've been handling this myself this whole time, or perhaps they have been, we can present evidence to say, no, that's not true, and this is what they do, and this is how they pay their bills, and this is what they do when they go see, so you lay out your evidence, whether they can or they can't. So diagnosis alone, it's important, is not sufficient for the appointment of a conservatorship. And again, with a limited conservatorship, we need that tri-county report. So in a probate conservatorship, we're looking for the capacity declaration. In a limited, we're looking for tri-county's report that basically sets forth, what their limitations are and what powers would be appropriate for the conservator to have. Okay, so we know what we have to do. We have to file our petition. We have to serve the appropriate people. We have to get a court hearing. We have to present evidence, sufficient evidence to the court. So now the question is how does one qualify to be appointed? So I already know any interested person can file, right? But how do you really qualify to be appointed? Again, number one thing throughout the whole process of the conservatorship proceeding is what is in the best interest of the proposed conservatee. Okay, so even if you have someone that's interested and they've filed the appropriate paperwork and they've done everything that they're supposed to do and filed it with the clerk's office, they still have to go through an investigation process to make sure that they're the right that they're the right person to be appointed to step into this person's shoes and start making rather large life decisions on behalf of another. Okay, so the process that we have is we have the Superior Court Investigator Mediation Department. And it is their job, once a petition for conservatorship is filed, to go out and initiate an investigation. And I have to say, our local investigator's office is quite phenomenal, very diligent, very skilled at understanding and appreciating the dynamics of the families that we deal with and the disease process. So what they do, and by law they're required to do this, is they obviously have to meet with the proposed conservatee. They have to meet with the petitioner, the proposed conservator. They are supposed to try to meet with all the relatives within the second degree to get their input as well, because who better knows what's going on behind closed doors? Who better knows the relationship dynamics between the proposed conservatee and the proposed conservator? The family, right? They also, if they can, have to contact neighbors, social workers, tri-county case managers, as many people that have contact with this individual to kind of paint the larger picture for the court. The court investigator is a neutral. They're a fact gatherer for the Superior Court. And the purpose is to gather the information and then make a recommendation to the court. Okay? The court, especially in a limited conservatorship situation where we're dealing with developmentally delayed adult, and a situation where a conservator is asking specifically for dementia authorities to place them in a secured perimeter facility and to administer dementia medications, those are mandatory appointments of counsel for the proposed conservatee. In every conservatorship proceeding, the proposed conservatee is entitled to counsel. In those two specific situations, dementia powers and limited, it's a mandatory appointment. In all other cases, if the court determines it would be in the best interest to appoint counsel, the court will appoint counsel. And I will tell you, in the majority of our conservatorship cases in Ventura County, the judge appoints counsel, and that counsel is the public defender's office. And I have a colleague, his name is William Lenahan, who does exactly what I do. There's 2 attorneys in my office that get appointed to represent these conservatees, and we have 1 attorney in our mental health department that gets appointed in all the mental health LPS conservatorships. So there's 3 specifically in our unit that deal with these types of cases. So the proposed conservator also has to complete what are called confidential documents, confidential supplemental information. They have to tell us, have you filed for bankruptcy? We want to know that, right? Because they're going to be managing finances. Do you have any criminal convictions? Have you been convicted of elder abuse, perhaps, embezzlement? We need to know these things. The court investigator will do a criminal background check so that we know who we're dealing with, who's going to be taking care of this individual. And they also, under penalty of perjury, have to state whether or not there's a conflict of interest. Do they owe money to the proposed conservatee? Does the conservatee owe them money? You know, is there commingling here? Do we need to separate? We need to know as much information about this proposed conservator. Again, why? To determine whether or not this person would be the best person. Is it in the best interest of this proposed conservatee to have this individual appointed? So the investigator will collect all this information, consolidate it into a nice report, and that report will be provided to the judge and the parties in the case, okay? And now the attorney that's appointed to represent the conservatee will do the similar type of investigation. Okay, so let's say I'm appointed in a case. I'm obviously going to go talk to my client. I need to do my own, and I'm not a doctor, okay, but I need to make my own independent assessment of what deficits does my client have? What capabilities does my client have? You know, how should this conservatorship be structured, or how should it be granted at all? is this the person that's the best person? So I go through a similar process and talk to a lot of the same individuals. So there's a bit of a duplication in efforts. The distinction between the court investigator and myself, for instance, is that I am the attorney and I am the advocate. I'm the legal advocate for the proposed conservatee. The court investigator is not an advocate. They are a reporter. They investigate, gather, and report. Okay? So that's the major distinction. I go in court with my client. I make representations to the court, and if there is a hearing that needs to be had or any litigation that's going to occur, I would be their legal counsel to assist them in that process. So that's the major distinction. So there is some overlap. And we heavily rely on the court investigators because they are required by law to go out to the home or the facility every single year to check on the well-being and to make sure everything is still going smoothly. Okay, so to qualify to be appointed, is it in the best interest? Do they pass the court investigation, criminal background check, all of that? Okay. A private conservator, meaning just a family member, friend, or interested person, doesn't have to have any special qualifications per se, like educational qualifications. I mean, obviously, the more complicated the estate is, the more skill level you're going to want your conservator to have, because there's a variety of perhaps legal proceedings, that they have to attend. They have to be able to find the appropriate professionals and CPAs and tax advisors and lawyers, whoever they need to help manage this estate. And so you do kind of have to look at what their skill set is, but just an individual doesn't have to, prior to their appointment, have certain educational background. But you do look at that depending upon the needs of the conservatee, because again, the whole focus is the conservatee and their protection. And you want the person that's going to be appointed to be the most appropriate person to manage everything that needs to be managed. Now, in addition to private people, a family member, friend, neighbor, etc., we have what are called private professional fiduciaries that can also be appointed as conservators. Okay? Now, private professional fiduciaries do have qualifications that a family member would not have. They have to be 21 years old, okay? They do have to have educational degrees. It can be a BA or a BS or an AA and AS with 5 years of experience in managing or providing care services. They have to have 30 hours of approved courses by the state. They have to clear, of course, the criminal and civil background, just like an individual would have to. They have to engage in continuing education in all these areas that involve management of somebody else's life. And they have to register with the state registry, okay? We have a handful of private professional conservators in Ventura County. There are many, many more when you go into the LA area because we have a lot more people over there. Our private professional fiduciaries are phenomenal. The cases that they manage and handle are incredible, complicated estates, sizable estates with all kinds of family dynamics involved. In our local jurisdiction, when you have a complicated estate and you have, let's say, competing petitioners, and that's something that I haven't mentioned before. We file petitions, right? But can there be more than one petition? Absolutely. You can have 2 people, 3 people file a petition, say, I want it, I want it, I want it. Now you're like, okay, well, who? And so now you have competing petitions, okay? In our local jurisdiction, the judge usually in those situations, if there's no resolution among the parties, and there doesn't look like there's going to be any resolution, and there's just this bleeding of the estate because of all this litigation, the court will strongly recommend and suggest a private professional fiduciary to remove the conflict. Okay, and to preserve the estate. Now, one thing that I haven't mentioned, you're probably wondering, how is all this paid for, right? Because this can be very expensive. Just to file the petition is over $400, okay? And you're like, well, how can people do this? Well, the cost of a conservatorship is paid for by the conserved person's estate. Okay, so the person who says, I want the job, is not personally responsible for the cost That's good, because lots of people wouldn't step up to the table if that were the case, because they wouldn't be able to financially, okay? Not because they wouldn't want to. Now the question becomes, well, what if the proposed conservatee doesn't have the money? Well, that's a good question. The filing fees can be waived. There are there are local forms actually that can be completed. Let's say the individual is a senior and their only income is a very small pension and Social Security income. In those instances, this form is filled out. It goes directly to the judge. The judge reviews it, and the judge says, oh, this is a small estate. I waive the fees. Okay? The court investigator, every time the court investigator goes out to do an investigation and all the subsequent investigations, $600. Okay? That can be waived as well. The attorney costs cannot be waived. Except, now obviously if you have a conservator, oftentimes they will seek private counsel, because this is a foreign process to most of us, right? And it seems complicated, and you don't know what to do, and how do I do this, and how do I serve that, and how do I get it on calendar? Well, you hire a lawyer to do all of that, and you take the worry out of it, and you know it's going to be handled correctly. Generally speaking, unless they're offering their services pro bono, they're going to be charging their hourly rate. And local rates can be anywhere from $325 an hour on up. Now, our local judge kind of caps the hourly rate in the probate court. I believe it's currently at $350, and that can change depending upon the judicial officer. And other courts, family law courts, there's no cap. It could be $450 an hour, okay? So when the attorney takes on the case, obviously, they're going to be looking at, well, how sizable is this estate? You know, can it afford this? An attorney cannot be paid out of the conservatee's estate without prior court approval. So let's say daughter, the do-gooder, says mom needs a conservatorship. She hires a private lawyer. The lawyer says, I'm X number of dollars an hour. You know, I want a retainer of X. And the daughter goes, all right. You know, I'm on a joint account with mom. I'll just go pull the money out and here you go. Can't do that. Okay? If daughter wants to dip into her pocket and advance the funds, that's totally okay, because that's not out of the conservatee's estate. It can only be paid upon a petition before the court. The court reviews the fees, determines their reasonableness, okay, looks at the size of the estate, and then either grants it, doesn't grant it, or cuts it. Now, as it relates to the public defender's office, we are a really good deal because our hourly rates are significantly lower than the rates that are obtained in the private sector. And it's set by the Board of Supervisors, so it has nothing to do with us. And we, too, can petition for fees, and we tend to petition for fees in those estates that can't afford it. Of course, public defenders, as we know in criminal matters, are appointed to represent people who are indigent. So there are going to be many conservatorship matters where their estate is very small, and they can't afford all of private counsel fees and filing fees and the public defender services. And so we may waive our fees, or we may be very conservative in our fee request, or we may even wait until the conservatorship is terminated to ask for our fees, because our goal and our focus is the conservatee's benefit. And our policy basically has been to take a kind of big picture approach and look at what are the needs of our client. What are their medical needs, placement needs, how much money do they have? Obviously nobody has a crystal ball. We have no idea the longevity of life. Perhaps this person has many years to go and they're going to need every penny they have. And so we fortunately can take that position and treat that a little more conservatively to try to help our client's estate last as long as possible for their care. Okay, so that is how all of this is paid for. Okay. In addition to going through the investigation process and determining if the proposed conservator is the appropriate person, they also have to qualify for a bond. If the estate is receiving anything above Social Security income, and their estate is more than $15,000, they have to qualify for what's called a bond. Now, the bond is like an insurance policy, so that if the conservator decides, hey, this is easy money, I'm going to take it and run, we've got a bond in place for the amount of the estate, so that we can perhaps collect that money from the bond or insurance company and then later seek it from the conservator if it's available, okay? And there is a whole process for that. And so they have to qualify for a bond. So some people might have bad credit, or they've perhaps recently filed for bankruptcy. An insurance company or bonding company might not feel comfortable posting a bond for them. So they have to be able to qualify for a bond. So if it's a sizable estate, you want a conservator that's got a good credit background. It's got, the ability to post this bond. Now, again, the expense of that bond doesn't have to be paid by the proposed conservator. It is going to come out of the conservatee's estate. Nonetheless, they still have to qualify personally that they're appropriate financially to handle somebody else's finances. Okay, so that's how you qualify. Okay, those are all the hoops that you have to jump through. It sounds complicated. It is a process, and I always try to assure or reassure proposed conservators that once we get to the hearing, you have done most of the hard work. Now, unless it's a complicated estate, now it's going to be smooth sailing. You're just going to get back to your everyday, day-to-day stuff and helping take care of your loved one. So there's a lot of this paperwork and meeting with your lawyer and figuring out who gets what ahead of the hearing, and then you attend the hearing. So what happens at the hearing? As I mentioned before, the proposed conservatee is entitled to have a jury trial, or they can have what's called a court trial, which is is a hearing strictly in front of the judge. No peers from the community, and the evidence presented directly to the judge. Testimony is given, doctors testify, perhaps loved ones, family members, friends testify to establish the need or lack thereof. And then the judge would make the decision of, is a conservatorship needed? And if so, is this the appropriate person to appoint to be the conservator? Okay. So everybody comes to the hearing, the petitioners. It's an open courtroom, so anybody can come. So if any of you are interested and just want to check it out, Tuesdays is our conservatorship calendar in the morning from 9 to noon. It's usually done before noon. So if you want to see what happens in court on conservatorship matters, go to the Juvenile Justice Center, which is on Vineyard and Oxnard, room J6 on the second floor, and you can just sit and observe and see what happens. So we're at the day of the hearing. The petitioner is there, and if they're represented by counsel, their lawyer is there. The proposed conservatee must be present, okay? Unless the capacity declaration that I mentioned earlier, the doctor checks the box that they are unable to attend. And oftentimes I will see a capacity declaration that says unable to attend because they can't understand anything. Well, that's not the criteria. Unable to attend means they're bedridden, okay, and they can't physically make it, or there would be some physiological detriment to their attendance, okay? Just the fact that they can't comprehend what's going on in the proceedings, that is not sufficient. The reason for that is the judge is making an adjudication of incapacity, and all he's seeing is a bunch of paperwork, right? He wants to see the person. He wants to talk to the person, the proposed conservatee, so that he himself or she, whoever happens to be on the bench, can make their own quick initial assessment. Yes, what I'm seeing matches up with the evidence that I've been presented. And so the judge wants that opportunity. Now, every once in a while, myself and my colleague might have a client that says, I don't want to go, I don't want to go, I don't want to go. They're scared, they're paranoid, they're uncomfortable, they're okay with the proceedings, they're okay with the proposal. I just don't want to go. And it's going to cause them a lot of anxiety. We as their counsel can go to the judge and explain to the judge their reluctance, the reasons therefore, the fact that they don't object, and we want to proceed in their absence. So there is that exception, okay? But generally speaking, the judge does want to see the proposed conservatee, so he or she can determine, is this truly appropriate for this person, okay? So let's say the proposed conservatee does not object. There's not going to be a contested hearing. The hearing itself is rather brief because all the evidence has already been submitted and filed with the court. And so, it could last 5 minutes, 10 minutes. Yeah, I know. It's amazing, isn't it? Like I say, all the hard work is kind of prepping it and presenting and gathering the evidence for the judge. And then when you go there, if there's no conflict involved and there's no contest as to whether it should or should not be granted, it's a rather quick proceeding. Okay? Now, in the packet of papers that are filed with the judge, there is what's called an order. And it's an order appointing the conservator. And this order is specific as to what authority the court is giving to the conservator. So at the end of the hearing, the order is immediately signed by the judge, assuming there's going to be no litigation, okay? That order is handed back to the petitioner, the petitioner's attorney. They walk downstairs to the clerk's office. They hand that order to the clerk. The clerk then files that order and then issues what is called letters of conservatorship. The order and the letters of conservatorship are the documents that you as the conservator would present to the world on behalf of your conserved person saying, I now am in charge. I am the one now that is going to make all of the decisions pertaining to this conservatee. Now, keeping in mind, we have the distinction between conservatorship over the person and conservatorship over the estate. So let's say, for instance, the conservator is only appointed over the person. Now, that order and letter is going to be specific to that. So it's going to be limited to that. Medical decisions, placement decisions, okay? So your order and letters doesn't mean just all of a sudden expansively you can do everything. It depends on what that specific order grants you the power to do. And the letters have to be consistent with that order. And so what you're going to do is you're going to go to the banks and you're going to go to the doctor's offices and all those people that you're dealing with on behalf of your loved one. Proof that you are now the conservator. And so it is their obligation now to deal directly with you. Okay, and you as the conservator can allow access to your siblings or other loved ones to talk to these professionals, but you are the responsible person. You now have a fiduciary duty to protect your conserved person and make all decisions in the best interest of this conserved person. Okay. Once you are appointed the conservator, it doesn't end there, sorry. Not only do you have to have the day-to-day care of the individual and the ongoing bill paying and debts and all of that, you've got reporting obligations to the court. Once a conservatorship is established, the court becomes the big supervisor. And it must continue to oversee the conservatorship and make sure that it's hundreds of conservatees out in the community, if not thousands at this point, are being truly protected and treated properly, and their estates being properly managed. So let's say the conservator is appointed over both the person and the estate. They have to file 60 days after their appointment what's called a care plan. And the care plan is essentially this. The judge wants to know, is the conservatee in their home? Why is that important? Well, isn't it important to all of us to remain in our home? Isn't that where we want to be, especially if we're in our last chapter of our life? That's where we want to be. And so the court needs to know, where is my conservatee? Is my conservatee in their home? If not, where are they? And if they're not in their home, are they going back to their home? And if they're not going back to their home, why not? So the whole focus is if at all possible, can we get our conservatee back home? And in many instances, we can't. Perhaps they need 24/7 care that is not affordable by their estate. And so they have to be placed in skilled nursing facility and perhaps qualify for Medi-Cal. Okay, there's a variety of reasons why maybe they need medical care that can't be provided in the home. Okay, even if there's a hired caregiver, it's just that level of medical care that can't be supplied in the home. So that is the purpose of the care plan. Okay, if the conservatorship is over the estate, the judge needs to know, well, what is the estate? Because the judge needs to know from the date of the appointment of the conservator, what are we dealing with? Because it needs to follow the money. All right, and so the inventory and appraisal is a document that establishes all the assets of the conservatorship estate. Now, here's a distinction to note. There's a conservatorship estate, and there's what's called a trust estate. Some of you may have a trust, and some of you may have transferred your assets into the name of the trust. That's a different and separate entity. So let's take a look at scenarios where there's no trust. All of your assets are just in your name as an individual, okay? When you file that inventory and appraisal, you're going to list all those assets. The majority of those assets, unless they're cash assets, are going to have to be appraised by a probate referee because the judge wants a professional that's going to give it a fair market value so that we can kind of see how it grows or doesn't grow over the term of the conservatorship. Okay, the bank accounts, of course, we're dealing with cash accounts, so the conservator can list, okay, in B of A, we've got $20,000 or whatever the cash may be, okay? And then household furnishings, furniture and furnishings, you can kind of give an estimate of that. Jewelry has to be appraised, real estate has to be appraised, things that are above and beyond cash value. So that document, the inventory and appraisal, has to be filed within 90 days after your appointment. So now we have a starting point, because if the estate is above, and there are some exceptions as always, $15,000, okay, the conservator is going to be required to file accountings. That means the conservator has to keep track of every penny that comes in and every penny that goes out. The conservator cannot commingle their assets. They must keep the assets of the conservatee separate and apart from anybody and everybody else. They must title all accounts in the name of the conservatorship. So it basically puts the world on notice. Hey, this account is under a conservatorship and it's protected, okay? And so we have a starting point. So when we receive that first accounting, we know exactly what we started with, and then we see all the expenditures, and now we see what we have at the end of that accounting period, and we can see if it has been managed appropriately, okay? After the accounting, after the first year of appointment, you have to file also what's called a status report. And basically that status report is just kind of keeping the court apprised of where's my conservatee, how's my conservatee doing, what medications are they on, any special programming, what are their finances looking like. It's not an accounting, but just kind of general monthly expenses. How are those monthly expenses being met? Is there a trust? Basic information. It's a 3-page document, and most conservators who are on the ball can fill it out with information in their head. Okay, that gets filed the year after they're appointed and then every year thereafter. Okay, and that's how the court, in addition to the annual court investigator visits, stays on top of monitoring its conservatees, in addition to the accountings in those cases where the accountings are required. If it's a small estate, below that $15,000, or they're only receiving Social Security benefits, the court will waive the requirement of an accounting. Now, the person who's in charge of managing those Social Security benefits, they're likely the payee of those Social Security benefits, and there's going to be some kind of accounting requirement to the Social Security Administration, okay? But the court is not going to monitor that. Unless there's some concern that's brought to the court's attention, like, I think there's mismanagement going on, then the court at any time can order an accounting, even if it's considered a small estate. Okay? So that's how the judge stays on top of the individuals. Now, you can see gaps. There are long periods of time where bad things can happen. And this is not foolproof. And so we must rely on the credibility, reliability of the conservator that is appointed to make the decisions on behalf of the conservator. That's why it's so important to go through that process and make sure that that person who is being appointed is the best, most appropriate person to be appointed. Okay. Now, we've filed the petition, we've got our conservatorship granted, we filed it, we've got all our reports. Now, you're probably wondering what rights are being affected, okay? What rights of the conservatee are affected by this conservatorship? Well, based upon what we've covered so far, obviously medical rights, okay? If the conservator has asked for exclusive medical authority to make exclusive medical decisions, that covers every medical decision, okay, that needs to be made on behalf of the conservatee. So the conservatee could lose the right to make his or her own medical decisions. Now, it is the job and duty of the conservator, depending upon the disabilities and limitations of the conservatee, to talk to them, include them, provide dignity, incorporate them. Not, I'm in charge, forget about you. That is not the goal here. That you want to incorporate the conserved person as much as possible and make them feel like they're still making decisions, but it is the conservator who's ultimately responsible for gathering the information, talking to the professionals, making the ultimate medical decision in the best interest of the conservatee. The conservator also gets to determine living arrangements. Where? Where are they going to live? Who are they going to live with? The interesting thing about that is if you are granted that power, which is a general power upon the appointment of a conservatorship, the conservator can place a conservatee anywhere in the state of California. Okay? If you want to place mom or dad outside of the state of California because you have a sibling over there that just retired and has all kinds of time to take care of mom or dad, which isn't a bad idea, okay, you have to go to court and get permission to do that. You can't just swoop your conservatee out of the state and send them away. You cannot do that without court authority. And if you do, the court will order you to bring that person back, unless, of course, you go through the right process. And if that is appropriate, and sometimes it is appropriate, what the court will order the conservator to do is file a like proceeding in that state. And like I said before, it could be called a conservatorship or it could be called a guardianship in that state. So they have to, unless they determine that it's not needed anymore, presumably it's needed. It was needed here, and they don't lose the necessity once they leave state, right? So presuming it is still necessary, then they would have to file like proceedings in that state, go through this similar process. It's not necessarily going to be identical, okay, because different states, different laws, different procedures, and they have to get that established. What the court will do is it will set a 4-month hearing out, so it kind of makes you get the ball rolling sooner rather than later. You come back in 4 months, and we determine status. If it's been established, then the court will go ahead upon the final accounting, assuming an accounting was required, then terminate the conservatorship, and the case would not be transferred. It would just be a whole new proceeding in the other state. Okay. In addition to living arrangements, the conservator can make decisions regarding education, programming, senior day programs, anything that's going to, help the individual. Maybe it's therapies or whatever the individual needs, and that's the assessment that needs to be made. That's their responsibility. Associations and relationships, the conservator can control that as well. In regards to the estate, the appointment of a conservator over the estate is an adjudication by the court that the individual lacks capacity to contract. Okay, so once that's granted, boom, no longer do you have the ability to contract. You can't bind your estate, you can't sell anything, transfer anything, encumber anything, incur any debt. Not to say that your estate isn't incurring debt, but you as the conservatee can't. You can't make gifts, you can't delegate powers of appointment, and you can't waive any beneficial rights that you might have, and you certainly cannot serve as a fiduciary either. Okay. So those are the rights that could be affected. What are rights that are retained? Now, keeping in mind, all of this can be modified by the court. These are general rules of law, okay? The court can make it more expansive or more limited. But generally speaking, the rights that would be retained by a conservatee would be if they are still working. Let's say it's a developmentally delayed adult and they work at Vaughn's, for minimum wage. They might be allowed to control a wage or salary, maybe, maybe not. To provide for the necessaries of life, go grocery shopping, buy personal hygiene, the basics. Make or change a will, which probably surprises you. A will has a low capacity level. To make a trust requires the ability to have capacity to contract. A will, you just need to know what your stuff is, basically who your heirs are and who you want to give it to. It's pretty basic, okay? In many conservatorships, however, even that right is removed, but generally speaking, that right can be retained. The ability to marry can be retained, to receive personal mail, to receive visits from family and friends, to obviously be represented by a lawyer, and they retain the right to go back to court once a conservatorship is established and ask the judge to change the conservator because it's not working out, or to end the conservatorship. So those are the general rights that are retained. So let's say you are the conservator, you've petitioned, you've gone through all the hoops, you've qualified, you've posted your bond, you've filed everything, you've got your order, you've got your letters. What are your powers? Okay, what are your powers? If you are a conservator over the person, the first thing you need to do is to assess your conservatee's needs. Makes sense, right? What do they need? What am I going to be responsible of taking over for them? Okay, where will they live? In regards to where they live, what you must consider is the least restrictive and most appropriate placement. So you can't, out of convenience to yourselves, decide, oh, it'd be so much easier to place mom or dad in this facility over here because then I don't have to worry. Well, the analysis has to be, is this the least restrictive, most appropriate placement? Okay, and that's a legal standard. So it's an analysis that you have to make in your decision-making process as to where they will live. Obviously, you have to help keep your conserved person healthy, secure health insurance if they don't have it, deal with medical issues and work with all the treating physicians, whomever they might be, review their medications, make sure that they're receiving the appropriate medications. Maybe they appear to be overly medicated. It's going to be your duty to consult with physicians and to do an assessment of whether or not medications need to be adjusted. Arrange for all dental, podiatry, and eye care, secure in-home care if that's necessary or needed, help them maintain a good diet, provide their clothing, arrange for recreation and social contact, tap into whatever resources, and you know where they are, for seniors or the developmentally delayed individual. And first and foremost, of course, protect them from harm and protect them from harming others. That is one of your duties. As it relates to the estate, you have to gather the assets. You have to find out what they are. You have to secure them, bank accounts, safe deposit boxes, stocks, bonds, real estate. Whatever is in their estate, you have to find it, gather it, change the titles into the name of the conservatorship, so you're putting the world on notice that this person's estate is being protected by this conservatorship. Again, as I mentioned earlier, you cannot commingle your assets. You have to pay all their bills and expenses. If they have debts, you have to deal with those. If somebody owes them money, you need to deal with collection. If they have claims that need to be resolved, you need to help resolve those. File taxes. Consult with any legal professional, CPAs, etc. And again, file your reporting, your inventories, and your accounting responsibilities, assuming that the estate qualifies for that. Okay. When it comes to an accounting, that's a whole nother subject, and that's rather detailed. There are judicial counsel forms. If it's a sizable estate, that is not something that an individual generally would do themselves. They would seek legal counsel to do that because they're very specific types of accountings. It's not a general accounting that you might be familiar with from a CPA. They're very form specific and statute specific. Okay. They are reviewed by volunteer auditors, so you have multiple eyes kind of checking out the dollars and cents and making sure that these accountings are done properly and the money's been managed appropriately and properly. Okay, so those are going to be the powers that you're going to, maybe you'll receive some, maybe you'll receive all, but in your petition, you're going to be very specific as to what you think you need to help take care of the conserved person. Okay, now, so we've gone from the beginning, you're appointed, all of your responsibilities, your powers, and the rights that are affected. How do you end a conservatorship? Okay. Well, you can resign. Okay. The conservator can resign. That doesn't necessarily mean that the conservatorship is going to end. Okay. Because the need still may be present, right? Just because you don't want the job anymore for whatever reason, maybe your health, maybe you're moving out of state for whatever reason, it doesn't mean the conservatorship is no longer necessary. In that situation, the court has to look for a successor conservator. So somebody else kind of needs to step up to the plate and file a petition. So that's one way. If there is evidence to support the fact that a conservatorship is no longer necessary, let's say it's a person who had suffered a stroke, and through therapies and treatments, they've recovered, okay, and that happens, then they may no longer need the conservatorship. So what we would do is we would present evidence to the judge, supporting medical evidence to the judge, supporting the fact that this person has regained all capacities and can now manage their person as well as their estate. So we would file a petition to terminate the conservatorship with all the supporting evidence to support that they have regained their capacity and it's no longer needed. Okay, the court, not only can a conservator resign, the court can remove a conservator. There are many instances when the court will and can remove a conservator, and obviously if they breach one of their duties, if they have done something to harm in some form or fashion the conservatee, they have mismanaged, they have financially abused, they're not providing the proper oversight or care. And I'm not saying direct care, but making sure that they receive the care that they need. They're not filing all the necessary reports with the court. They're not filing their accountings, their status reports. They're just not in compliance. The court can say, you're not doing your job. I remove you. And then again, we're in a similar situation as where a conservator wants to resign. We need somebody else in place. Now, in cases where there might be only one family member, maybe nobody else willing or able to step into that job, the last resort is the public guardian's office, okay? When there is still a need for a conservatorship, it is, and there's nobody else willing, able or capable to handle that job, it is the public guardian's office responsibility to step up, file a petition, and now become that individual's conservator. Okay, so it is a public agency then that becomes responsible for all those things that I've just talked about. Okay, the other way that a change in the conservator would be obviously if the conservator passes, then we would need to again find another conservator to step into his or her place. A conservatorship over the estate could be terminated. Let's say we start out with an estate, years have gone by, the money has been spent down, and there is no more money left. The petitioner or the conservator can ask the court to terminate the conservatorship over the estate. Now, oftentimes that isn't done because if the estate goes below that $15,000 mark, there's not going to be an accounting requirement, so that kind of expense goes away. Oftentimes, I recommend to keep the conservatorship over the estate, even though there's no real estate to manage, primarily because that tells the world that this person is being protected by the conservatorship, prevents the conservatee from entering into any contracts that you have to try to undo down the road, and it allows the conservator to continue to deal with outside third parties, financial institutions and whatnot, because they're still conservator over that estate. Okay, so it's oftentimes a good idea to maintain that, but technically speaking, if there's no more estate to manage, you can go in and request to have it terminated. And then, of course, if the conservatee passes, there's no longer a need for the conservatorship, and so the court is presented with a death certificate, and if it's a state that requires an accounting, a final accounting will be presented. Upon approval of that accounting, the conservatorship will be terminated. Okay? And then whatever assets remain at that time are handed over to the personal representative, executor, etc., and then the estate is managed after death. And so, in a nutshell, that is all about a conservatorship. Any questions? Yes?
Wait, my turn. Mary, I don't want this to happen to me.
I don't want it to happen to you either, Dave.
Thank you.
Nor myself. But you can, Dave. Remember, you can plan ahead.
As an individual, I have the right to ignore medical advice in managing my own health. Does the conservator assume that right? And stated another way, is there a legal concept of malpractice for a conservator in managing health if the person dies after the medical advice has been ignored? Is there a legal?
There could be liability. I've been practicing in this area for coming up on 12 years now, and I have yet to see that case. However, a conservator can be liable for his or her decisions or non-action, okay? We all do. We're presumed to have capacity, and we are autonomous, meaning we are allowed to make our own medical decisions. But when we are under a conservatorship, that decision-making ability is delegated to the conservator, and the conservator must make medical decisions that are in the best interest of the conservatee. Now, in determining what is in the best interest, they have to take into consideration medical advice. They have to take into consideration any specific religious beliefs and any designated documents, healthcare directives, et cetera, as to how they want to be treated in the event that they have an incurable disease, okay? So all of those things have to be taken into consideration. You cannot have a conservator that simply says, you know what, I don't believe in this stuff, and I'm not going to have my conservatee be subjected to this. And yes, there is potential liability there. Family members, again, is there a deep pocket? There's so many factors to take into consideration, but they could be responsible. They absolutely could. And if it deals with a decision relating to an estate and the mismanagement of an estate, they can be surcharged, meaning if there's a dollar amount involved, they can be ordered to reimburse the estate X number of dollars. So it is the conservator that is going to make that medical decision, and they have to kind of look at it globally and determine what is in that person's best interest. Yes.
This is one quick one. I met you first at an ombudsman presentation.
That's
and
right.
Thank you. That's where it's so helpful. One thing that we have seen is somebody does get a conservatorship after quite the process, and they have a person in an assisted living facility, say. Is it their right to keep daughters? I think this has been a big court case recently, actually. Can they keep relatives from visiting just because they don't think that's a good thing?
Technically, they can.
Okay.
They can. And again, everything to do with a conservatorship has to be premised on what is in the best interest of the conservatee, okay? So let's say you have a dysfunctional family situation, and let's say one of the family members comes to visit mom or dad, and when they do, they talk about all inappropriate things. They get mom or dad worked up. They create unnecessary anxiety. It impacts their well-being, okay? That is a best interest analysis. The conservator cannot simply say, Joey, I don't want you to go see mom because I can't stand you. No, that doesn't qualify, okay? So again, if there is a conservatorship and the conservator has made that decision, the conservatee should have counsel, okay? So counsel can be consulted. The conservatee can talk to their lawyer and say, I don't like this. We need to go back to court and deal with this, or I want you to deal with this. So there are avenues to deal with it, okay? But technically speaking, the conservator does have that authority and ability, but they need to utilize that with the best interest standard in mind. Mm-hmm.
Thank you very much for the presentation.
Oh, you're welcome.
Hugely helpful.
Oh, wonderful. Thank you.
I'm wondering where the power of attorney fits into all this. If I decide that I am unwilling, maybe unable to take care of all my finances, can I give power of attorney to my favorite relative? And does that avoid
It could over your estate only, because a power of attorney is only dealing with your assets and not your person, okay? So if you have a power of attorney that you've had drafted during your period of capacity, meaning you knew what you were doing, you knew you were giving, assigning this to an agent, and you knew what powers you were giving to this individual, you can potentially avoid a conservatorship over your estate. That power of attorney doesn't deal with your person and your health care and your well-being and medical decisions. So you want both of those documents in hopes of avoiding a future need for a conservatorship.
You could get a power of attorney for health care.
Absolutely. They're two separate documents.
Okay.
Any other questions?
Thank you so much, Mary. Thank you.
Thank you for having me. It was a pleasure.
All right, what are we going to do now with our last 2 minutes?
Oh, I was going to go ask Mary.
You've lost your chance. All right. Well, listen, folks. We're going to terminate this particular session. Remember some of the things we talked about today, whether it was the intergenerational activity, Senior of the Year. All these things are available to you here in our community. A lot of it is dedicated towards the senior community, but there are intergenerational things occurring also. Don't forget to buy local, because that's what keeps us all rolling around here. Don't forget to buy local whenever possible. And with that, I bid you adieu till next month, April 2nd.